Till now, we have done 186 webinar in last 4.5 years. And so many people from industry, regulatory bodies, member of parliament, civil servant, and professionals have joined this. Friends, today's topic is very important and apt because what is happening, the Insolvency and Bankruptcy Code 2016 is a comprehensive framework designed to facilitate the timely resolution of insolvency and bankruptcy in India. That was the main purpose of this. Otherwise, we have seen the winding up taking 10 years, 15 years, 20 years. And because of this reason, the Indian ease of doing business ranking was always low because of this one reason, that you can form a company, you can start a business, but you can't close the business. So this insolvency code has helped in this. But the implementation of IBC often interact with various other laws such as Companies Act, SEBI Act, tax law, labor law, competition law, arbitration law, SURFACE Act, and various other laws. And this creates a complex legal landscape, and there is always confusion because what is happening, the lawmaker is clear, but the implementer, the officer, they always confuse and they always create a hurdle in this. And because of the interpretation, because of the practice, because of so many things. So we want to understand how these law interface with the IBC is crucial for navigating the resolution process effectively. Because when we talk about the resolution plan should be completed within the design timing, then it should not have any hiccups related to interpretation. Additionally, implementing resolution plan presents several challenges, including coordinating among stakeholders, addressing conflicting legal provision, and ensuring compliance with multiple regulatory requirements. This session today's will explore the interaction of the Insolvency and Bankruptcy Code with various laws, such as I mentioned the names, various law, Companies Act, SEBI Act, taxation, and other things. The webinar is designed to address these complexity, providing insight and practical solution to improve the effectiveness of the resolution strategy under the IBC. So we will discuss all these points, that what are the challenges in implementation, what are the strategy to effective resolution, and how these conflicting things are coming in between. So we are crossing the timeline. Now, I want to welcome all the speakers for today's program. Mr. Amit Gupta, PCS, insolvency professional. Then we have Mr. GP Madan, founder Madan Law Office and Eminent Task Force co-chair of ASOCHAIR. Then we have Manoj Kumar, partner head, M&A and transaction corporate professional. Mr. Rishabh Singhal, senior associate, insolvency professional, corporate professional. Friends, I welcome all four speakers for this program. And as you are aware that we have a system that any of our speakers which is regularly coming, we don't introduce him because you people are knowing very well. And that's why we save time for giving question answer. So today we want to discuss all these things with these expert panel. And interestingly, Amit is a practitioner, insolvency professional, all are there. Amit is a practicing company secretary. Madan is a practicing lawyer. Manoj is a consultant advising various structuring. And Rishabh is doing work on the insolvency resolution plan. So we have a combination of all. We will get the all types of information from the court point of view, from the resolution point of view, COC point of view, the corporate, the all other aspects, various interaction with regulatory bodies or various regulator in this. So it will be a good combination of speakers as well as their knowledge base. So today we will discuss the key issues. One is that challenges in implementing resolution plan, strategy for effective resolution and interface of different laws with IBC 2016 that we will cover. Now, interestingly, when we were doing this research, now Companies Act, that is talking about the winding up, merger, restructuring in companies, IBC supersede all laws. Companies Act, SEBI law, SERFACI, arbitration, income tax. So they staying related proceedings and having overriding effect. So whatever mentioned in winding up, merger and restructuring, IBC supersede all. Then come to the listed company, where the guideline of listed company insider trading disclosures are there. But SEBI regulates listed entity, but IBC procedures can proceed precedents in insolvency cases. So here also the stock exchange as SEBI has their own criteria, but IBC supersede all these things. For take example, the stock exchange is putting penalty on some company, but as per this insolvency law, they will be operating creditor and they will get what is available, not what you are desiring. Then in the SERFACI Act also allows recovery of dues through auction and defaulters property, but IBC overrides SERFACI during insolvency proceedings, except where secured creditor be enforced outside IBC. Sometimes what is happening is secured creditors, they have a asset that is charged, so they don't want to go into this arbitration, this insolvency process, and they say we will recover money from the asset. So that is one challenge. Arbitration in commercial dispute, arbitration is usually stayed under IBC unless it is beneficial to creditor or preserve assets. Income tax also, income tax and all tax liabilities, tax recovery provisions are there, and that is a huge amount. But tax recovery is stayed under IBC. Tax claims are treated as operational cost debts, and now slowly, initially everybody faced problem, but now it is clear cut. Now everybody is realizing, including income tax, and this process is smoothing. Then we have a Competition Act, prevent anti-competitive practice and regulatory combination, but here it is not overriding effect. Resolution plan must comply with the competition law and seek approval if required. That is another aspect which we can say this law you can't override. Now, challenges in implementing resolution plan, which is a part of the today's topic. Implementing resolution plan under IBC 2016 is challenged due to valuation dispute, delays from litigation, lack of bidders and complex business operation, regulatory compliances, resistance from existing management, coordination amongst creditors, legal uncertainties and adverse economic condition. Further complication, the compliance process is cumbersome, often leading to prolonged and inefficient resolution, and that's why the entire process is delayed and not as per the decided timeline. Now the question is, these are the challenges, but how we should overcome this? So for this, we will discuss today strategy for effective resolution, that how effective resolution under IBC involve accurate asset valuation, minimize delay, attracting multiple bidders, ensuring regulatory compliances, strong coordination amongst creditors, experienced resolution professional, and clear communication with stakeholders are crucial. Adapting plans to market condition and providing economic incentive can also help attract investors and achieve successful resolution. Now, these are the strategic point, and we will also discuss when the speakers and panelists will discuss that what points we should take care while drafting of resolution plan, role of prospective resolution applicant, monitoring committee, others implementation, challenges faced in implementation, discuss on various areas such as waiver of debt, assignment of debt, sale of assets, change in board of directors, capital reduction, capital allotment, listing, board decision making, change in auditor, requirement of board, shareholders approval, regulatory approval, compliance, delisting, increase in minimum public shareholding. Both you may go for delisting, and if you are not going for delisting, the majority shares comes with you. So then within particular time frame, you have to go back to the normal 75%, and then they have a 2 times that up to 90% you have to reach, then 75%. So they have given timeline. Then consequence of non-implementation of resolution plan, possibility of modification of resolution plan, and change in successful resolution applicant. So these are the things today we will discuss. Topic is big, but the speakers, those who are handling day and night all these things, I expect that they will give crisp answer of all these points. So with these things, I will invite my speakers. So first I'll tell you the structure. First, we have a Rishabh Singh, Senior Associate Corporate Professional, Insolvency Resolution. He will give the presentation on these aspects. Yeah, what is the resolution plan, how it can go. And then after, GP Madan, Amit Gupta, and Manoj, they will discuss all these points. First, we will discuss what are the problem, and second part we'll discuss on how to solve how to come out with a perfect resolution plan. What are the problems we always do in this? With these things, I will invite Rishabh to give a presentation. But before this, I just want to announce that our knowledge sharing is continue, and our next webinar will be held on 6 September. Topic will be announced to you shortly. And till then, I'll request Rishabh to take up this matter and give a presentation on these aspects.
Thank you so much, sir, for providing me with this opportunity. Now, I would like to share a PowerPoint presentation.
Yeah, it is just, okay, just go to slide share and we start.
Yes.
Yeah, it's okay.
Right. So the first topic is interface of different laws with IBC. As we know that IBC was enacted in the year 2016, and Section 238 of the IBC gives it an overriding effect over the other laws. So what we have seen generally that when Section 14 moratorium is levied during the CIRP process, then what happens that all the proceedings against the corporate debtor remain stays, apart from the criminal proceeding, that is 138, etc. So generally, we have observed that all the other laws, if they are inconsistent with IBC laws, then the IBC law will prevail over the other laws. For example, IBC and SARFAESI. So before the enactment of Insolvency and Bankruptcy Code in the year 2016, the financial institution and other institution, they approach DRT and other courts under SARFAESI law for the recovery of their dues. And they generally auction the residential or commercial property or whatsoever the security they are having without approaching the court, and they were free to conduct auction for that particular thing. However, after the introduction of IBC, the secured creditor generally they prefer going through the IBC route, and if any proceeding under SARFAESI is going on, then it has to be stayed in view of in terms of moratorium under Section 14 of IBC. So it clearly says under the IBC that once a CRP is initiated, the moratorium is applicable to any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property, including any action under the SARFAESI 2002. Then coming to IBC and taxing statutes. So we have seen that even during the moratorium period or when the CIRP proceeding is going on, when tax authorities, they generally in accordance with Section 52, they fall much lower in hierarchy as compared to secured financial creditors, workmen, employees, etc. So generally, they recover their dues by attaching the property. So this question came up for consideration in Leo Edibles and Fats versus the Tax Recovery Officer, Income Tax Department, Hyderabad, Andhra Pradesh High Court. So the court observed that an attachment itself creates no interest in a property, and the tax department does not enjoy the status of secured creditor who can avail provision of Section 52 under IBC. So basically, under IBC, the waterfall arrangement as given in Section 52 and further described in elaborated manner in Section 53, it deals about the distribution of funds when the company generally goes into liquidation. That is first the CRP cost or liquidation cost, followed by financial creditors, then workmen, employees, operational creditors, then government dues, etc. So therefore it was held in this matter that the incorporation of Section 238 of the code makes it obvious that the code will override anything inconsistent contained in any of the enactment. Now coming to Arbitration Act. So it has generally been observed that once the CRP proceeding starts, the arbitration proceeding going against any of the company, it generally stays. I mean, simultaneously IBC proceeding and arbitration proceeding cannot go. So Section 238 has overriding effect over this, and arbitration proceedings is stayed. The Honorable Apex Court, that is the Honorable Supreme Court, in the matter of K. Kishan versus Vijay Nirman Company Private Limited, held that challenge to an arbitration award under Section 34 of the Arbitration and Conciliation Act 1996, amount of existence of dispute under IBC. Therefore, CRP cannot be initiated. So in this matter, when any pre-existence of dispute is present, generally IBC cannot be initiated. But once this IBC is initiated, that is CIRP proceeding or liquidation proceeding, then all the proceedings under arbitration is generally stayed. Now coming to resolution plan, that is challenges in the implementation of resolution plan. So for that, firstly, we need to know that what is a resolution plan. So resolution plan is defined under Section 5, subclause 26. And the person submitting a resolution plan is known as resolution applicant, and the same is defined under Section 5, subclause 25. So what is a resolution plan? So once a corporate debtor, that is the defaulter company, goes into corporate insolvency resolution process, then the then the appointed IRP, later on appointed as RP, as per the timelines, publishes Form G under Regulation 36A of the IBC. Pursuant to this, any person who is interested in the revival of the company. Why I'm using this word revival of the company? Because generally people tends to initiate IBC just to recover the amount. But the ultimate aim of the IBC is resolution of the company rather than liquidation or recovery. So any person who is entitled or who is interested in the revival of the corporate debtor and takeover of the business of the corporate debtor may submit the expression of interest as per Form G. And once their name is mentioned in the list of prospective resolution applicant, then they may submit a resolution plan, obviously based on the information memorandum which they have been provided, within the specified timelines, along with the earnest money deposit and other requirements as laid down by the COC, that is a committee of creditors. Generally, committee of creditors consist of financial creditors who have the voting right. But in case if any company is not having any of the financial creditor, then in that case, operational creditors forms the committee of creditors, and they are vested with the voting rights. Then the plan submitted by the prospective resolution applicant is placed before the COC for its consideration, and after the detailed negotiation and modification, the COC approves the resolution plan with a majority of 66% in accordance with Section 30, Subclause 4 of the IBC, read with Regulation 39. Then after the approval of this resolution plan by the COC, the resolution professional files an application under Section 31 of the IBC before the Honorable NCLT for the approval or rejection of the resolution plan. So Regulation 37 of CRP regulation provides that the resolution plan submitted is for the maximization of value of assets, but not limited to the following: transfer of all or part of the asset of the corporate debtor to one or more person, sale of or part of assets, whether subject to any security interest or not, restructuring of the corporate debtor by way of merger, amalgamation, or demerger. The substantial acquisition of shares of the corporate debtor or the merger or consolidation of the corporate debtor with one or more person, cancellation or delisting of any share by the corporate debtor. Fourth one is satisfaction or modification of any security interest. Coming to next slide is a provision regarding implementation of resolution plan. So Section 30 of the IBC code speaks about the mandatory contents of the resolution plan. Basically, it gives details of the requirements which we need to follow while preparing a resolution plan. The main points are like that resolution plan should not be conditional. It should not be in violative of any of the prevailing law of the country. Section 30, subclause 2D states that RP to confirm that resolution plan provides for implementation and supervision of the resolution plan. Then coming to approval of resolution plan, the Honorable NCLT, after receiving the resolution plan, approved resolution plan from the COC members, generally approves or reject the resolution plan based on the representation. Now coming to provision regarding implementation of resolution plan in the code. Regulation 38 speaks about the mandatory contents of the resolution plan. 38.2 states that the term and implementation of the plan schedule, the management and control of the business of the corporate debtor during its term. So what it has been observed that once the plan is approved by the Honorable NCLT, a monitoring committee is formed. And during this period, who will be the concerned person to look after the management and affairs of the corporate debtor? Then Regulation 38, subclause 3 tells resolution plan shall demonstrate that it has provision for its effective implementation. That is from where the source funds is being given to all the creditors of the corporate debtor. Then Regulation 39, subclause 9 states that a creditor who is aggrieved by non-implementation of a resolution plan approved under subsection 1 of Section 31 may apply to adjudicating authority for directions. Next slide deals with the effect of approval of resolution plan by adjudicating authority. So once the resolution plan of the corporate debtor is approved, so the new management gets the corporate debtor on a clean slate. Like they are not supposed to pay any of the past dues or pending dues in form of claim, obviously in form of claim, which has not been admitted by the resolution professional. For example, if any creditor suddenly arises after the approval of resolution plan and they want that their dues to be cleared. But if they have not submitted their claims during the CIRP process, then their claim ceases to exist and they will not be eligible to get any remedy under any law in India. So effect of resolution plan by adjudicating authority. So in the matter of Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company, the para 86 states that the legislative intent behind this is to freeze all the claims so that the resolution applicant starts on a clean slate. and it is not flung with any surprise claim. If that is permitted, the very calculation on which the resolution plan is submitted would go haywire of the plan, would be unworkable. The word other stakeholder would squarely cover the central government, any state government, or any local authorities. The legislature noticing that on account of obvious omission, certain tax authorities were not abiding by mandate of IB code and continuing with the proceeding, has brought out the 2019 amendment so as to cure this set. So recent development with respect to the modification of resolution plans. So what we have observed in many matters that once a resolution plan is approved by the COC and is finally submitted before the adjudicating authority for its approval, no resolution plan is supposed to be amended. So in the recent judgment of Deccan, the issue before the Honorable Supreme Court was whether the adjudicating authority's approval for grant of ownership right over trademarks, Deccan Chronicle and Andhra Bhumi, following the COC approval of the resolution plan, wherein ownership rights were not part of the resolution plan submitted, amounted to a modification or alteration of the approved resolution plan. The Honorable Supreme Court held that the COC approved exclusive use of the trademark and not their ownership, and therefore any right or ownership claimed over the trademarks post-approval by the COC stand extinguished. The court held that order passed by the NCLT granting ownership right over the trademarks would amount to modification of the resolution plan, thereby rendering it impermissible. Further, in the case of M.K. Rajgopalan, the Honorable Supreme Court dealt with the issue of submission of revised resolution plan by the RP to the adjudicating authority without getting it approved by the COC. The court held that any revision is subject to the final approval of the COC and RP cannot submit a revised resolution plan to the adjudicating authority. So generally, we have observed that during the recent trend and recent changes in this IBC scenario is the Honorable NCLT, NCLT, and the Honorable Supreme Court, they are mostly following the commercial wisdom of the COC. So in this matter also further, this case serves as a very important precedent as it clearly establishes that under any circumstances, the resolution plan must get approved by the COC at its final stage before it is sent to the adjudicating authority for approval. The court opined that there is no concept present in the IBC permitting any post facto approval of a resolution plan by the COC, which has not been placed before the adjudicating authority. The court further stressed upon the fact that even certain aspect of the resolution plan, which may seem procedural or technical in nature, cannot be overlooked. Each aspect of the resolution plan must be approved by the COC and no modification can be made by the adjudicating authority once such plan is approved by the COC. So steps pursuant to approval of resolution plan is as follows. So once a resolution plan is approved by the Honorable NCLT, then a monitoring committee is constituted. Then generally the structure of monitoring committee is like one insolvency professional should be there in the monitoring committee, one representative of financial creditors, and one representative of the resolution applicant. So this is the minimum. It depends on plan to plan that how monitoring committee is being constituted. So after the constitution of monitoring committee, the next step is calling the meeting of the monitoring committee towards the appointment of director or any key managerial person as proposed in the plan. Then filing of document to ROC regarding the changes in directors and any updation like INC 28 GNL forms are to be filed before the ROC. Then modification in capital structure by way of resolution in the meeting and necessary forms before ROC. Then control and custody of the corporate debtor to be handed over to the new management. Generally, it has been seen that the resolution plan term consists for a period of 6 months to 1 year. So during this period, who will be the concerned person to look after the management of the corporate debtor, because the erstwhile management, they are not into the picture. The resolution professional duty cease to exist upon the approval of resolution plan. So now when the monitoring committee is there, it is decided that who will be the concerned person to look after the management and control of the corporate person. Then there are certain challenges which is faced while the implementation of resolution plan. Past liabilities are invalid after approval of resolution plan. So it has been observed that many creditors who fails to submit their claims as on the insolvency commencement date or after a period of 90 days after the insolvency commencement date. So they tends to file a frivolous application before the Honorable NCLT or any other tribunal just to delay this process. And in the matter of Committee of Creditor versus Satish Gupta, it was decided that undecided claim after the approval of resolution plan cannot be entertained. Then pending litigation delays the implementation. So it has been observed that once the plan is approved by the Committee of Creditors, it is generally placed before the Honorable NCLT to for its approval. And NCLT takes time for the approval of plan generally 12 to 15 months. So this delay is due to multiple reasons, which includes multiple application filed by many parties. That is, first is erstwhile management. Sometimes they file a frivolous application against the resolution applicant or the COC member or the resolution professional or any of the operational creditors, sometimes the statutory authorities, income tax, GSTs, etc. Then impossibility to perform the duties mentioned in the plan. The resolution applicant proposed plan to acquire debt-ridden corporate debtor company. To do the same, a period of 30-90 days is generally given by NCLT. Sometimes the approval of the plan by COC as well as NCLT, it becomes impossible for resolution applicant to complete the agreed upon integration activities. The impossibility can be of various reasons. Example, due to natural calamity, unforeseen circumstances in the business of the successful resolution applicant, pandemic, lockdown, etc. And it has been, for example, let's take a hypothetical example that when a successful resolution applicant submits a resolution plan before the COC, and the COC approves that resolution plan. And by the time it gets its approval from the Honorable NCLT, a period of 2 years is lapsed. And in this period of 2 years, the functioning of corporate debtor was not there. So the value of the plant and machinery, obviously, it gets deteriorated. So after the period of 2 years, the prospective resolution applicant sees that it's not feasible to run this plant because during the period of 2 years, all the plant and machinery, they are in scrap condition. So this is one of the classic case where impossibility is there to perform the certain duties in the resolution plan. Another example is OTS by the corporate debtor. So what happens that once this CRP process start, the Form J is published, resolution plan is invited, resolution plan is submitted. Further, it is approved by the COC member. Then what happened? The erstwhile management generally offers a one-time settlement with the COC member, and it is the commercial wisdom of the COC to approve that. In the classic case of Appu Hotels Limited, this same thing happened, that a resolution plan was approved by the COC, but later on the erstwhile management of the corporate debtor, they proposed a OTS settlement, and they were obviously paying a much more higher amount. So the same was approved by the COC member again. I mean, the consideration of OTS was done by this COC. So the same was approved by the Honorable NCLAT also. Then delay tactics by the promoter. Sometimes promoter files frivolous application just to delay the process. They file frivolous OTS application and all. The other relevant factors with respect to the approval in resolution plan is there have been instances where operational creditors holds up for approval of resolution plan by filing multiple application, which they insist being taken before the hearing of the application. Also, the Honorable NCLT generally wishes to clear all the pending application before the approval of resolution plan, which also includes PUFE application, that is preferential undervalue, extortionate, and fraudulent transactions. The other issues with respect to the implementation is resolution plan is issues pertaining to the required compliances under Companies Act, issues pertaining to tax liabilities, issues regarding sectoral regulators. So issues pertaining to the required compliance under the Companies Act, that post approval of the resolution plan by adjudicating authorities, there are certain tasks which needs to be carried out by resolution applicant under the Companies Act. That in terms of section 31, the resolution applicant shall, pursuant to the approval of resolution plan by adjudicating authority, obtain the necessary approval required under the law for the time being in force within a period of 1 year from the date of approval of resolution plan by the adjudicating authority within such period as provided for in such law, whichever is later. That it is pertinent to note that in terms of explanation provided under section 30, if any approval of shareholder is required under the Companies Act 2013 or any other law for the time being in force for the implementation of actions under the resolution plan, such approval shall be deemed to have been given, and it shall not be a contravention of the act or law. However, there is no such deemed approval in respect of approval of ROC and filings. Then approval and compliances. After the approval of resolution plan, that the change in the status of the company for from CIRP to active with ROC, that filing of INC 28 and other needs to be done. Reconstitution of the boards of the corporate debtor, then restructuring of the capital base of the corporate debtor, then filing of the annual return, MGT 7 balance sheet, etc. Then change of the status of the company from CRP to normal process. Then issue in reconstitution of the board of director of the corporate debtor by appointing new board of directors. So when a company appoint or removes a director, DIR 12 form is filed on MCA portal along with the fee, and the process is carried online after the approval of resolution plan. After the approval of resolution plan, the monitoring agency holds a meeting to appoint director of the company and remove the old director. After that, certain forms are to be filed, that is DIR 12, DIR 2, INC 28, certified copy of the resolution plan, etc. Issue with regard to restructuring of capital base of the corporate debtor by extinguishment of erstwhile paid up share capital from existing shareholder and to update it with new paid up share capital as per the approved resolution plan to the new shareholders as inducted by the resolution applicant. So the process under Companies Act to increase authorized share capital of the company during the general course of event, Form SH is filed. Then the process may require the payment of additional fee, or sometimes it may not require. However, the process is quite simplified and only requires filing of form appointed under Section 164 of the Companies Act. Issues pertaining to tax liability. So generally, we have seen that the past tax liabilities of the corporate debtor generally extinguishes once the resolution plan is approved, and the claim submitted by income tax department is generally dealt in the resolution plan. So profits chargeable to tax remission or cessation of liability. Section 41 of the income tax speaks that where an allowance or deduction has been made in the assessment for any year in respect of loss, expenditure, or trading liability incurred by the SSC, and subsequently during any previous year, the first mentioned person or the successor in business has obtained, whether in cash or in any other manner, or expenditure or some benefit in respect of such trading liability by way of remission or cessation thereof, the amount obtained by such person or the value of benefit occurring to him shall be deemed to be profit and gain of the business of the profession and accordingly chargeable to income tax as the income tax of that previous year, whether the business or profession in respect of which the allowance or deduction has been made in the existence in that year or not. Section 170A of the Act was inserted while Finance Act 2022 in order to make provision for giving effect the order of the business reorganization issued by tribunal or court or adjudicating authority under the IBC 2016. The section provides that in case of business reorganization where a return of income tax has been filed by the successor under Section 139 of the Act, such successor shall furnish a modified return within 6 months from the end of the month in which such order or business reorganization was issued. Then Finance Bill 2023, substitution of a new section for Section 178, Clause 77. For Section 178 of the Income Tax Act, the following sections shall be substituted, namely effect of order of tribunal or court in respect of business reorganization, notwithstanding anything to the contrary contained in Section 139, in a case of business reorganization where prior to the date of order of High Court or Tribunal or an adjudicating authority as defined in Clause 1 of Section 5 of the IBC 2016. As the case may be, any return of income tax has been furnished by an entity to which such order applies under the provision of Section 139 for assessment year, relevant to the previous year to which such order applies, the successor shall furnish within a period of 6 months from the end of the month in which the order was issued, a modified return in such form and manner as may be prescribed under the code. Then Section 79 speaks about carry forward and set off losses in certain companies. Notwithstanding anything contained in this chapter, where a change in shareholding has taken place during the previous year in the case of a company, not being a company in which the public are substantially interested, no loss incurred in any year prior to the previous year shall be carried forward and set off against the income of the previous year, unless on the last day of the previous year. The shares of the company carrying not less than 51% of the voting power were beneficially held by person who beneficially held shares of the company carrying not less than 51% of the voting power on the last day of year or years in which loss was incurred. Subclause 2, nothing contained in subsection 1 shall apply to a company where a change in the shareholding takes place in a previous year pursuant to a resolution plan approved under the IBC 2016 after affording a reasonable opportunity of being heard to the jurisdictional principal commissioner or commissioner. Then Section 115 JB of the Act provides for levy of minimum alternate tax on the books profit of a company.
Yeah, Rishabh.
Yes, sir.
Okay. So, anything else pending?
This is from my end, sir.
Okay.
Yeah.
Okay, that's fine. You have given in detail the entire thing and changes also. So now I will start with Manoj, Amit, and Madan sir. Madan, we will cover what are the challenges of different law, but first I want to start challenges in implementing resolution plan. So you, Amit, and Manoj should tell us in brief from your side that what are the challenges, and then we'll the second part we'll do is strategy for effective resolution. So first, Madan sir, from your side, what are the challenges in implementing resolution plan? And then I will do this effective resolution, and simultaneously I will ask you in between In company law, what are the issues which you are facing? In the SEBI law, what are the problems you are facing? We'll discuss that also. Over to you, GP.
Thank you, Pawanjan, giving this opportunity. And I must compliment Rishabh for such an exhaustive presentation on this implementation of the plan in such a short time. Very nicely, the issues have been captured in one particular PPT.
Thank you, sir.
You know, when it comes to challenges, the challenges in implementation of the resolution plan are different in each plan. It depends upon the size, it depends upon the assets, it depends upon the industry, depends on the regulator. And there are so many other factors. Let me give you one example. Suppose it's a real estate project. Now, in real estate project itself, the challenges would be different whether the real estate is in the city of Noida, Greater Noida, Yamuna Expressway, or in Gurgaon, or in southern part of the country or western part of the country. Let me take an example. Suppose this real estate project is in Noida or Greater Noida. Now, recently what has happened? All of a sudden, in one particular case, where the project has been implemented, the resolution plan was approved in the year 2020, August 2020. And after that, resolution applicant started implementing the plan. And almost 90% of the project is complete. In the meantime, the construction is over. However, the plan approval order of NCLT was challenged before NCLAT. NCLAT dismissed both the appeals. The appellants were Greater Noida Authority as well as one another UP Awas Vikas. Now, against that NCLAT order, both the authorities went to Honorable Supreme Court and filed two different appeals. Now, in February 2024, Supreme Court comes out with the judgment in case of appeal filed by Greater Noida Authority that Greater Noida Authority is a secured creditor. They are operational creditor, but simultaneously they are secured creditor, and secured creditor gets a priority under Section 53 of the code. Therefore, as far as the resolution plan is concerned, the priority should be given to them and an amount equivalent to the liquidation value of the assets of the corporate debtor should be given to them by the SRA. Now, all of a sudden, the whole Pandora box is opened, and that has actually impacted many other resolution plans which were already approved by the various COCs, and applications for approval were pending before the adjudicating authority. Now, in all those cases, what has happened, including in this case where the judgment has been passed by Honorable Supreme Court, that all the resolution plans now have been remanded back to the respective COCs. And now respective COCs have to consider these plans again. In some of the cases, now COCs are asking the resolution applicants, the successful resolution applicants, to submit the revised resolution plan, taking care of the interest of this secured creditor, that is Noida or Greater Noida Authority. And in some of the cases, in one case recently, Bench 2 of NCLT Delhi has remanded back the matter to Committee of Creditors and given complete discretion to the COC. Given complete discretion to the COC that it may ask the SRA to submit a revised plan. COC may start the revaluation of the assets, or COC may start with issuance of fresh Form G. Now, see, at this stage, when it has already been 3, 4, 5 years of the approval of the plan by the Committee of Creditors, all of a sudden the law has been rewritten and these authorities have been made secured creditors. So this is the, as a real estate is concerned within this region, this is the one of the major implementation challenge being faced by the SRAs. Another challenge which is being faced by the SRAs is with respect to SRA, here I mean successful resolution applicant. Another challenge being faced by these claims which are being filed by PF department. This is one of the major challenges in majority of the cases. Number one, there is no timeline for the PF department to file a claim. They may file at any point of time, and they are getting the order. Their delays are being condoned by the adjudicating authority. And because of the Jet Airways and some other judicial pronouncements, what has been held, what is being held nowadays, that all the dues of the Provident Fund, whether it's employer dues, whether it's employees dues, or interest on those dues, or damages, or interest on damages, all this is to be paid to the PF department. Now think of this, that the resolution plan amount is 100 crores and a aggregate of all these claims of PF including interest, damages or interest on damages comes out to be 120 crores. It means the entire amount of the plan is likely to go to PF department. What for those COCs there? Now this is acting as a major deterrent as on date, and therefore the number of banks have nowadays decided not to invoke the provisions of Section 7 of Insolvency and Bankruptcy Code by filing in a petition under Section 7, rather than invoking the provisions of SARFACI and whatever the assets are mortgaged to them to recover the amount from there and the remaining amount from the personal guarantors. So to that extent, this is derailing the provisions of the code. And I think there recently many proposals have been given to Ministry of Corporate Affairs that in this proposed budget, not budget session, but in the winter session, whenever the government comes out with the amendments in the Insolvency and Bankruptcy Code, clarity is provided in the code that how the dues of the PF or this ESI or other government dues should be taken care of. All of you must be aware that last year, when Supreme Court came out with a judgment in Rainbow Papers case, where it was decided that Gujarat VAT is also a secured creditor. Now, Gujarat VAT department declared as secured creditor, and once is a secured creditor again has to be paid in terms of Section 53. After that, various NCLT benches have passed number of orders that even this income tax department is also a secured creditor. So now in the law, Pawanji, we need to complete clarity whether what shall be the what is the outstanding dues to these government departments, whether they are to be considered in the resolution plan or not, are they secured creditor, are they unsecured creditor, will they get priority over the payment which is being made to the financial creditor? Because if financial creditors lose faith in this system, certainly in that scenario, it will be a big failure of the legislation. But all of us are here and we need to ensure that this law remains, because if you read the preamble of the code, it is nothing but reorganization, restructuring. And in the interest of restructuring, and as you said in your opening remarks, Pawanji, that this legislation is there for the purposes of exit. Because in India, it was being said that entry is easy and exit is difficult. So for the purpose of that exit, that early liquidation, early disposal of assets and early realization of the assets, this law needs to remain. So we must ensure that this law remains, and whatever are the outcomes of these judicial pronouncements or other orders of various judicial authorities, we must request the Ministry of Corporate Affairs to provide clarity on all that. I'll come back to there. Number of other challenges to the implementation.
Just tell me one thing.
Yeah.
When some NCLT is saying the income tax is secured creditor or VAT is secured creditor, then the issue of payment is also there, because these people will not go by your resolution plan, they will go by their own demand. So they may pressurize the company, a resolution applicant also.
That is what is actually happening. Despite Ghanshyam Mishra judgment of Honorable Supreme Court, number of successful resolution applicants are challenging this. That these departments submitting their claims, and then they're saying, no, we are secured creditors. Number one, these amounts have not been assessed. So whatever the amount has been given in the claim, the SRA has to accept that. And when the amount is not assessed, and on what basis can we say that you are a secured creditor? Actually, if we read this Rainbow judgment or we read this Greater Noida judgment versus Prabjit Singh Soni, In both the cases, it has been said, first of all, you have to see whether a charge has been created or not. No doubt if charge is created, it will be in terms of Companies Act and charge will be registered there. But another issue of charge creation has come into force nowadays, that if any legislation, it has been written that for any outstanding dues to the government department, that government department shall have first charge over the assets of the corporate debtor. So no need of creation of any charge. So by virtue of this provision in the statute, the government department becomes a secured creditor. Now, I'm not pretty sure whether in income tax department we have such provision. I think in GST also we do not have such provision. GST gives priority to IBC. This is what my understanding is. But for now, each and every outstanding due to every government department, we must read the provisions of that particular legislation, that for outstanding dues in that particular legislation, the department is having charge over the assets of the company or not. If they are having charge, then that department becomes a secured creditor. And then second question comes about the claim amount and the assessment, whether the amount has been assessed or not. And then after that, I tell you, it's open. It should be, according to me, now it should be open to the SRA whether to accept that claim or not, because after accepting that claim, whether the plan remains viable or feasible or not. If the plan is not viable or feasible, he should have all the rights to come out of this plan. There should be exit door for him also. It should be shown to him. Rather, he should have free exit. And in that case, whatever the EMD amount has also been submitted, that should be allowed to be refunded. We need clarity on all these issues.
Okay. So now, Amit, your view, Madan has given his point of view. Your view on this aspects, that what are the problems in the resolution plan which you are facing today? Can you just explain?
Thank you, sir. Thank you, Madan sir and Rishabh, particularly for setting the tone for this deliberation, what we are going to make. And Madan sir has touched upon a very, very, very important subject with regard to the implementation part, especially with regard to the crown debts. At times, when I revisit this particular subject and go in the flashback when the committee report was received and the section 53 was proposed to be introduced in the law, saying that now crown debts will have a lower priority in comparison to the other. Now, when Madan sir was reciting the rainbow paper and couple of other judgments, then again I was compelled to rethink, is it really we are going in a vicious cycle where from we started, we are again now deliberating the same things and we are back to square one situation where we are now heading for. And the way he has explained, I'm sure lot more Pandora box is going to open in times to come. It's just a beginning. The way the resolutions plan have been approved without considering especially these two aspects with regard to the crown debt and the judgments with regard to the provident fund and the retirement benefits of the employees in couple of matters. I think these are going to be challenges, and regulator need to give a clear verdict. And as Madan sir was saying, this should become the essential component of your resolution plan itself, so that either the successful resolution applicant is able to appreciate it in totality and check the viability, whether it is viable, it remains viable even after inclusion of the same. The surprise element should be removed from the resolution plan. Otherwise, it will become next to impossible. I think that is the message what Madan sir wanted to give. And I completely echo with what he's saying. This is one dimension or one dimension to the challenges that corporate Inc. is facing with regard to the implementation. Let me take you to a little different dimension. Despite we have crossed almost 7 years and we are going to touch 8th year for the implementation of Insolvency and Bankruptcy Code, still the Ministry of Corporate Affairs, who happens to be the implementing agency for the Companies Act as well as the Insolvency and Bankruptcy Law, that is, both are their own baby. Still, the synchronization that is expected with regard to the transitions which are taking place at different stages, whether it is commencement of CIRP, whether it is commencement of liquidation, whether it is change of the status from CIRP to active status, or it is introduction of a director, change in the management. Every resolution plan gives us the same amount of pain that we were facing almost 7 years back. To give you the example, I am a successful resolution applicant, and I have mentioned in my resolution plan that ABC will be my new management and they will be my director. And resolution plan order, which has been pronounced by the NCLT, has been filed duly in form of INC 28 and has been approved also by the concerned authority. And now challenge is that past management, there may be 3 director or 4 director, none of the director either is traceable, or even if traceable, then he is not willing to affix his digital signature, saying that my powers were suspended way back by virtue of provisions of Section 17 and I am no longer in a capacity. Even if I am in capacity, then he is not willing to give his digital signature for introduction of a new director. We leave it here, where whatever be the situation, there is another option what we come to know by interacting to the IBBI. They say, all right, you file an application to the backend of Ministry of Corporate Affairs and Ministry of Corporate Affairs will help you. Ministry of Corporate Affairs says that there is no such process. I have a process in case where all directors are disqualified. I'll give you the process for appointment in those cases, but unfortunately for this particular case, there is no process. So you may request, but we'll take it up to the concerned department, and when they approve, then we will approve. So I am having cases in hand where we are not able to induct the director representative of the successful resolution applicant unless the monitoring agency intervene into between and coordinate with the ex-management and request them to support this filing of form, or IBBI intervenes into the matter and direct to the Ministry of Corporate Affairs to take the introduction of these directors from the back end. So this is first challenge that the successful resolution applicant faces at the very first moment. Second challenge that comes with regard to the implementation of resolution plan with regard to the inter-creditor disputes, which has taken place in many of the matters, and invariably wherever you see implementation where there are different categories of creditors, though the resolution plan has spoken about plain vanilla provision. This is not a legal issue, I'm saying. This is the issue which is primarily because my resolution plan has not talked in black and white in so many details, which was expected to be part of my resolution plan as to what will be the entire repayment plan, what will be the order of repayment, whether secured creditors will be paid first, unsecured creditor will be paid first. You have mentioned, all right, this amount will be paid. Dispute arises as to who will get the priority first. The funds of 100 crore have been infused. What will be the order of its utilization? Perhaps is missing part. That's why when we were talking with the Pawan sir also in afternoon, as to what is the challenge with regard to the implementation, I see when I go in flashback and say that the preparation of resolution plan itself in many of the cases is faulty. major challenge is the resolution plan drafting. I am not saying that all resolution plans are faulty, but I am saying with all responsibility, without any bias to any of the professional who is involved in the process of drafting of the resolution plan, but I am saying because many of the resolution plan, when they come to implementation, I'll give you the live examples. Example is that before that, the fundamental point with regard to the implementation is anything and everything which is part and parcel of my resolution plan does not require any separate corporate action. When I say so, that means if let us say I have to do the reduction of capital, or if I have to do the buyback, or if I have to do infusion of capital, or if I have to do increase in authorized capital, or if I have to change in the auditor, if any of these things, or increase in borrowings, or making the investment limits under 186, or maybe anything that we can envisage as a corporate action under the Companies Act and the SEBI regulation, then you don't require any separate resolution. Unfortunately, many of the resolution plan, when they draft all these paras of corporate action, they does not envisage that these kind of, I'll give you one example. In one of the resolution plan, they have included that the successful resolution applicant will infuse X amount of capital. Whereas the one part which was very important, the existing capital will stand reduced without following the process under the Companies Act. Now, result is when the plan came to implementation to me, I was having no option but to either seek a fresh permission from the adjudicating authority that this will also be covered and this will be a part and parcel of the resolution plan, or I'll have to follow the process of NCLT again for reduction of capital, because reduction of capital was not part and parcel of my resolution plan. This is not a fault of the law, but this is a fault of drafting of a resolution plan. In another case, when an entity which was listed, there was no mention with regard to how the transition of statutory auditor will take place. The plan says on the implementation date, on the cutoff date, and cutoff date was the date of approval of resolution plan by the adjudicating authority. The plan says on the cutoff date, the statutory auditor will demit his office, the existing statutory auditor. And this was a listed entity. And you know, the listed entity is required to prepare and submit the quarterly financial result within a time-bound manner. Now, let us say my resolution plan gets approved on 30th of May or maybe 30th of June. I have a very limited window available for getting my financial result approved, getting it audited, and appointment of a statutory auditor. The process was very easy if my resolution plan could have envisaged that statutory auditor also needs to be filled up. If they are demitting the office of a statutory auditor, all right, no problem. You propose how the statutory auditor will be appointed. If you don't do, then the appointment process, what is prescribed in the law, has to be followed. And in that case, you will be required the timelines which are prescribed by the law. These are just few of the areas in which we feel that the challenges are there. There are many more areas, I think, as we progress, because we'll take up, I think, SEBI law and all different delisting related and minimum public shareholding related. There are, of course, many other areas, but these are few of the challenges when I am saying that Ministry of Corporate Affairs, being the in charge ministry for both of the laws, insolvency and the Companies Act, they can very well take care. But unfortunately, I think still the sync of a common ministry is missing somewhere. We are not able to see the smooth transition coming in a way.
Okay, thank you, Amit. Thank you very much.
Pawanji, a short comment. A very important outcome of the comments from Mr. Amit is that most of these hurdles can be avoided at the time of preparation of the resolution plan. And at that point of time, because majority of the participant I can see are company secretaries, like at the time of secretarial audit report, they ensure that how many laws are applicable to this company. If they are first of all, it should be ensured that prior to approval of the plan and post approval of the plan, how many legislation will be there which will be applicable to this particular entity. And if we take care of the compliances of those laws and we ensure that all those laws are complied with, and whatever scheme, whatever permission approval which may be required, if all that is factored in at the time of preparation of the plan, I tell you the number of hurdles can be avoided during implementation of the plan. That is one of the beautiful takeaway from Amit's comments.
Yeah, that's absolute right, Manoj. Madan, you are absolute right. Manoj has discussed. There are some specific aspects I'm just asking all of you. There are 4 or 5 areas which are in different laws, and they are facing, and when you are interacting with that law, you are facing problem. So what I'll do, I will cover the strategy for effective resolution second. Let me just clear this. So first I will start SEBI regulation. Manoj, you are interacting with so many listed companies.
Yeah.
In the listed company, you must have seen that the shareholding has reached to 99%. Company is not going for delisting. They want to continue. Then they have to bring out the capital 10%, 5%, and then 75% as a gradual basis. Then listing fees issue is there. Then there are so many multiple issues are there. So can you just explain that what are the points where you face problem when you implement the plan?
So, in the beginning, there was no clarity as such how many percentage of holding can be there through a scheme of resolution. But now that part is settled. SEBI has modified the law, and now it is clearly saying, in any case, if you want to continue with the listing of a company which was listed and went for insolvency resolution, should not breach the limit of 95%. So at least 5% public holding will be maintained post resolution and at the time of listing. Then there is a gradual process given that this limit of 5% should be enhanced to 10% as per the process given by SEBI for achieving the minimum public holding now within 1 year from the date of relisting, and then or relisting or implementation of the resolution plan. And the third is to achieve the limit of 25% public holding within 3 years. So that timeline is already given, and the process is also prescribed, which includes offer for sale, right issue, bonus, etc. The 6 methods are provided. So that part is, I think, more or less settled. And the logic of this was that in the beginning, there were certain companies where the promoters holding went up to 99%. And because of squeezed holding in the public, there were a lot of price enhancement because of the demand and supply, extraordinary movement of price because of low volume. So SEBI tried to curtail that, and this modification has been done. However, obviously, as Amit and Madan sir was discussing, there are still a lot of confusions. What processes need to be followed for reclassification of the existing promoters, insertion of new persons, their directorships. If there is a time gap, what will happen? Then there may be certain issues which is relating to the fee payments. So sometimes, like SEBI or stock exchanges are taking coercive actions towards promoter group, the old promoter groups or promoter groups. Their demat accounts are getting frozen for non-payment of listing fees, etc. Even during the period of this CIRP process where the moratorium is there. So stock exchange and SEBI is saying that moratorium is available only to the company and not to the promoters, so they would continue to have coercive action against the promoters. So those there are many such smaller and bigger issues which crops up when we start the implementation. Some issues may be settled through specific provisions in the scheme itself, like Amit was telling. Some schemes are also faulty, and there are no speaking referenced for each of the situations, so which creates a lot of problem. And going back to NCLT would be a very time consuming process, so it is not advisable or not feasible for the company to go. So that creates a lot of problem for any listed company. And this during this whole period, obviously the smaller investor suffers. So that is also very important to take note of at all the time.
Okay.
Just to add what Manoj was explaining, we had got one very recent experience just a week back. We have got one resolution plan wherein there is not a iota of talk about delisting. It's a resolution plan about of a listed entity, whereas it is saying that post implementation of resolution plan, 75% will be held by A and 25% will be held by B. That means 100% of capital is going to be divided between A and B. And it does not talk anything about delisting. I'm not able to understand, and they have not done any announcement even to the stock exchange with regard to, because when your resolution plan is approved saying that the company is going to be delisted or the existing shareholders are not going to get any value, then it has to be intimated within 30 minutes of the announcement of the order.
Yeah.
No such compliance has been done, and brilliant part is that even it does not say that it is going to be a delisted entity after this implementation of resolution plan. I don't know really how to go ahead, and the promoters are, as you are rightly flagging, the reclassification also has to be done. There is no role of a regulator, but of course this is a bad drafting of a resolution plan.
Yes.
So
But
again,
I will tell you problem as an investor. I'm just telling you. There is a resolution plan. In the resolution plan, this is a listed company resolution plan, and promoter is the resolution applicant is not interested to continue the listing, and then the plan is finalized that it will delist. Now, why this particular thing is not going out in public? Why it is hiding? And because of this, there is a rumor in the market. People are manipulating, and the company which is going for listing, people are manipulating the share price. This is the first step government should do, NCLT should do, whenever they are passing an order of listed company and there is a clause that they are approving that this company will not be listing. They should highlight and they should give this message immediately. You communicate to the stock exchange that company will be delisted. So new investor or other people will not come under the trap. So that's one problem which I'm
to some extent, sir, they have already made
They
a
have already
regulatory
covered, yes.
framework. But difficulty is that the people who are drafting this resolution plan, they have now situation is that I don't know how to remove the shareholder, means how to reduce the capital. Means public shareholding is also there. Almost 40% of the capital is with public. Promoter holding will come to zero, I can understand. But how the public holding I'll make zero in implementation, I am completely blank with regard to implementation.
okay now.
Pavanji, I have two issues on this.
Yeah.
Number one, in my view, in all listed companies cases, SEBI should also be made a respondent. And NOC of SEBI should not be sought, but a report from SEBI at the order directed to be filed. Let SEBI go through the plan and come out with its comments so that tomorrow the other stakeholders of the company, they do not face any issue, any problem. Number two, coming to the drafting of the resolution plan, I'm reminded of the older days when the companies were being incorporated on the basis of the MOA and AOA available with the printers.
Yes.
वहां पे दिया order, उनसे copy उठाई और आगे बना दी company, because people were not ready to make payment to the professional to have a tailor-made MOA and AOA. And that is what is happening in case of resolution plans also. Many resolution plans are available in the market, copy paste करके, क्योंकि पवन जी जैसे और मनोज जी जैसे कंसल्टेंट तो पैसे लेंगे अच्छे रेजोल्यूशन प्लान बनाने के लिए. तो व्हाट इज हैपनिंग देयर, ओके इधर से उठाया उधर से उठाया, कॉपी पेस्ट किया, रेजोल्यूशन प्लान बनाया, सबमिट कर दिया विदाउट थिंकिंग ऑफ द कॉन्सिक्वेंसेस
Consequences, yes.
of this ill drafted resolution plan.
Yes.
And later then it takes months and years to gather a number of stakeholders face the consequences of the ill drafted plan.
That is right. That is right, Madan. Bilkul, absolutely right. So now, Madan and Amit and Rishabh, anybody, Companies Act में winding up merger and restructuring. Manoj, I will start with you first.
Mhm.
You are doing M&A, and now in M&A and the insolvency law, what are the major hurdles which is there in the law and which is overriding by insolvency law, but regulator, the government always stuck in this particular reading of between the lines what they are managing that particular law.
So IBC is an overriding law, and obviously it includes any resolution and restructuring can happen. Any kind of resolution plan can be made, which includes merger, demerger, or any type of similar corporate actions, which can be incorporated in and inbuilt in the resolution plan, and that is legally valid. So I think there is, and there, because the regulator approving authority is NCLT, I don't think there will be any major difference. However, there may be a challenge that certain, if we implement let's say amalgamation as part of the implementation of resolution plan, there may be a challenge what will happen to various provisions of 230 or 232 which are provided under the Companies Act. So there is no specific clarity with respect to the same, whether there is a requirement of shareholders approval or not, what will happen to that. But I think to most of the extent, these things are clear, and many of the schemes have also got approved as part of the resolution plan itself. So I think saying the two, what are the differences and what benefits or advantage we can take? Yes, IBC, if the company is under IBC, it is easier to implement any restructuring plan as compared to section 230. Simple 230, if you go and ask for a restructuring other than amalgamation or demerger, it is always very complicated because regulators are not willing to understand those nuances.
Madan and Amit, Rishabh, you have any point which is just confined to that part with their law and yeah.
I echo the views of Manoj. You know, if you ask me, according to me, IBC is nothing but old wine in a new bottle. It is nothing but a combination of SICA and 391, 394 of Virtual Companies Act 1956. Though it's a separate legislation, but it's another corporate restructuring activity only. Only thing is that some clarity is required. If the clarity is required, there's a wonderful legislation.
Yes, I don't think yes.
So
Okay.
I have one point which I have been flagging to IBI also since the inception of this insolvency. And when Manoj is saying that, yes, this is true that there are many successful implementation of amalgamation, demerger schemes through the insolvency law. Now, one aspect which needs the clarity from the regulator is as far as the merger part is concerned. In most of the matters, the corporate debtor will be the transferor company and there will be a different successful resolution applicant will be a transferee company, as I understand. Now, the corporate debtor, shareholder, creditor are already before the adjudicating authority. That I understand. But what about the creditors, shareholders, regulator of the transferee company?
The resolution applicant.
If there is any requirement of the approval of these stakeholder of the transferee company, despite being writing pointed questions or despite being discussing, so far we have not a clarity whether that approval is required or not. What circular of IBBI only states that if there is any approval, regulatory approval required, that can be that this resolution plan will be subject to that. That also I can understand. Now, difficulty is that suppose Competition Commission approval is required for any particular merger, right? This implementation is subject to Competition Commission approval. I don't think that intention is that my amalgamation order, which does not require any regulatory approval, will undergo a separate process of shareholder approval, adjudicating authority approval, post the implementation or approval of the resolution plan. That is one area which is, and on the other hand, Manoj, you also see why a shareholder, why a creditor who in general course of amalgamation transaction is given the opportunity of being consented for the approval is not consented for amalgamation in the insolvency law. Is a $1 million question. I am taking away his right by choosing a implementation where he has got nothing to do. He has no opportunity where he can say his grievance or say his any point. This also needs to be looked from that perspective. I'm not saying ki you withdraw, you allow all this process, but you allow a mechanism which is fair to all.
Okay.
I don't think there is any exemption to
No.
any company which is a resolution applicant that they will not implement, they will not follow the process provided under 230.
That is the problem, Manoj. That is the problem. Means transferee company is not exempted. But if you recall, I think there are almost 5 or 6 instances which I know. First one was ours only, and none of the company has taken any of the approval, and there are listed entities also being a transferee company.
Okay, Amit, that's fine. Now, last point related to this law point. Just tell me, the income tax we have covered, that income tax, the dispute, and the stamp duty we have covered. Just one point, SEBI law. Because now what is happening, there are so many creditors, they have a fixed assets with them, charged. So how much disturbance they create for resolution plan? Because they have an asset, they can take money from the security of that, so they are not interested in solving that resolution or giving assent or giving any participation in the resolution plan. How much this is a disturbance and how to solve this? Madan, you just said.
No disturbance, when you are in COC, so all secured and unsecured are equal. It all depends on the voting percentage. If the secured creditor is having much better voting percentage, certainly they will create problem. They can create problem, and they do create problem because they know it very well that we are having the maximum pie. Because they know it very well. In case the company goes into liquidation, then that scenario they are going to have priority.
Okay.
Otherwise, during CIRP, there is no distinction between secured and unsecured. But yes, if in the plan they are getting a handsome amount, certainly they don't say no to the plan. But only thing when they are being offered a lesser amount, they don't approve the plan, and they know it very well. In the case there is no plan or plan gets rejected, certainly company will go to liquidation, and then we will have
then they can take up. Yes. So section 53, 52, 53 clearly provides priority to those who have the first charge or security.
53 करेंगे, 52 में invoke कर लेंगे ना.
हाँ, invoke कर लेंगे. So they prefer such cases.
So they generally take the company into liquidation and then they relinquish their right and they sell the asset outside the
Okay.
IBC.
Okay. Now, friends, now this is all negative point, all things. Now come to the
No, we are given suggestions also how to overcome it.
This negative point means we are telling that these are the hurdles.
These are shortcomings of, as I said, again, it's a new law, the shortcomings have to be there.
Yeah.
This law is very important and very, very important as well as well drafted otherwise, but there may be procedural hurdles which need solution.
Manoj, new law is there, which is when we were taking 20 years to bind up the company, and today also, if it is reducing the timeline, it is good. But हमारा दिल मांगे more ना. So always we want that 240. जब 240 में होने लगेगा तो we'll say.
Sir, exit is one part, but problem is implementation में time बहुत ज़्यादा लगता है, value deteriorate होती है. That is the bigger challenge. So value should be preserved. That was the intent of this law.
Okay.
Now, मेरा humble submission आपसे यही है, because the MCA is very serious about bringing the amendments to the code. I think one session you should have what are the challenges before this legislation, what proposed amendment should be there.
Hmm.
And from your side, an exhaustive paper should go. It will really have a bearing on the.
So we will compile all the
Okay.
points which we have discussed today, and we'll share with all of you, and then we'll send it. Okay, now come to the strategy for effective resolution. So I will start, Madan, with you. That what give some idea, because some people are there who are resolution professional also, and the companies also, and we are here to solve the problem. So can you just tell how to do this so the minimum delay should take place? You can attract more bidder, you can ensure legal compliances, a strong coordination with all these things. What is your solution, suggestion? Then I will come to the Amit, you, and then Manoj and then Shah.
My first suggestion is that the entire CIRP process should be absolutely transparent.
Okay.
There should be exhaustive information memorandum from the resolution professional. The resolution professional should be there to investigate into the affairs of the corporate debtor, not from the investigation point of view, but to seek to know that what are the actual assets of this particular corporate debtor. If there are some hidden assets, he should explore the possibility of bringing those assets to the fold of this information memorandum. And once we have this robust information memorandum, and once we have this EOI process, once we invite the plans, at that point of time, it becomes the duty of the resolution professional also to see that all the creditors are getting the maximum and the value that this corporate debtor deserves is the corporate debtor is getting that valuation. And as we just discussed, this resolution plan drafting is the key to avoid these hurdles. One hurdle is nowadays everybody is talking about that there has been delay on the part of NCLT, but actually that is not delay on the part of NCLT, because NCLT is not equipped with requisite number of benches and requisite number of members it deserves. Recently, I met the NCLT president also, and he said we must have at least 200 members. And but in the recently after post budget, even Madam Nirmala Sitharaman has also admitted that there are going to be 30 NCLT benches in the country and with 115 members. Even if we have 115 members, I tell you, majority of the issues would be resolved. And then the members who are there at the helm of affairs, the government should induct only those members who are of judicial mindset and who understand the law. Now, what are the issues with respect to delay and implementation of the plan? I think Rishabh also highlighted many such cases. One of the problems which one can avoid is with respect to claims, delayed claims which are being filed. How to handle those delayed claims? Every resolution plan should be clear on the basis of the information being submitted by the RP, and RP must submit these are the claims, and in addition to this, these are the total number of creditors as per the books of the corporate debtor and who have not filed their claims. This entire list must be given to the SRR resolution applicants, and on the basis of those claims, then the resolution applicants, while submitting the claims, should consider all those creditors, how to deal with those creditors. A clarity should be provided in the resolution plan what amount shall be paid to them if the claim is, if suppose after the plan is approved by the adjudicating authority, and at that stage a claim is submitted, and if that claim is found to be genuine, I tell you, if you provide some amount for them, majority of these delay will go. Majority of this litigation will go. Nowadays, whenever application is filed, the bench asks us, the lawyers, is there any provision in the plan? The moment they say, yes, there is some provision in the plan, even at 25%, court says the application disposed of. But if there is no provision, then certainly court is also of the view, they were the creditors, RP should have known that, RA should have known that, something should have been provided to them. I think each and every creditor who has not filed a claim, please provide something to them to avoid, in majority of the cases, these delays.
Okay. Okay. Amit. Manoj, you start.
Yeah,
Huh?
I think Madan sir has clearly discussed most of the issues are we have already discussed. So I don't think there is anything special. Yes, the drafting of resolution plan is very important. Provision for each of the aspects, including all regulatory aspects, which all regulators, the entity is regulated by, what all provisions have been made for that, those compliances or non-compliances, for all kind of dues, statutory or otherwise, what are the provisions have been made, employees dues, etc. If everything is clearly written, if it is a speaking resolution plan, comprehensive resolution plan, well drafted, then I think challenges would be much lesser. And NCLT, obviously, the problem of NCLT would get solved in most of the cases, because they would not have challengers to the resolution plan, so they can fast track the approval of this resolution plan. So I think that part is very important. Clarity in law and clarity in implementation, both are very important. So that as soon as that goes, it will fast track the process, and it will help everyone, including the preserving the value of the things. But
Okay.
the challenges are there. The IPs are not well capable of handling all those things. There are only very few professional agencies which can support for a smaller size of companies and smaller companies resolution professionals. So those challenges would remain, and I think slowly the ecosystem will develop, and then only it will get resolved. So it will take some time.
Okay, Amit.
So I missed the question. Can you please repeat?
Question is that the strategy for effective resolution.
All right. So first thing, as I think Manoj and Madan sir has spoken about, and I have also been reiterating the importance of having a good drafted resolution plan. So importance of having good drafted resolution plan is the first step. When I say that we need to have a good drafting, then I also emphasize that the person who is uh, drafting the resolution plan, he should first of all create a roadmap from end to end as to from where he will start and where he will travel. If he is having complete roadmap available while considering the drafting of a resolution plan, I think these kind of mistakes will not happen. The type of gaps we are encountering while implementation, these kind of challenges can be divided into two buckets. One bucket is which are because of the regulatory challenges. Second bucket is because of the operational challenges. Operational perhaps can be addressed by way of a better drafting, by way of a clear roadmap. If we have a roadmap that this is how the creditors' dues will be structured, this is the payment schedule, this is the priority order in which the payment will be made, this is the charge restructuring that will take place. Because even the most of the cases, even the charges will be assigned to some of the ARC also. That is also quite a possibility. So whether you are going to sign a fresh agreement, what will be the document that will be required to be attached along with, when the document will be executed, what will be the roadmap. So you have to divide into the micro activities as well when you are drafting that out. And if that is done, I think most of the part with us which are regarding the operations can be sorted out. The things which are very few in number where we require the support from the regulator like IBBI or Ministry of Corporate Affairs, I think we can time and again reiterate and meet out to these regulatory bodies and give an emphasis that these are the bottleneck, these are the hurdles. I think those things will also get resolved. I'll request Pawan sir to use his good office to take this point with the concerned regulatory body as well. These are the challenges. I'm sure they will listen to us and they'll create a better ecosystem for implementation.
Okay, Rishabh, you have any point?
No, sir.
Okay, now I have few questions.
I take 2 points from Rishabh's presentation only. One is with respect to the frivolous applications. I think there should be clear-cut directions to the adjudicating authority to levy penalties or levy costs on the frivolous applications which have simply been filed to derail the entire CRP process. That is need of the hour. I tell you, many applications are filed just to derail the process.
Okay.
In one particular case, I tell you 16 resolution plans applications are pending before adjudicating authority, and one single common home buyer has created havoc. One single
There
home
are
buyer.
84 also in one matter.
No. I'm saying one single home buyer has filed the application in all those cases, and the entire resolution plan of those cases is getting delayed.
Yeah.
Now think of this: who is funding that particular home buyer? There are certain parties. It means he of his own he cannot afford to engage seniors, cannot afford to engage even a junior lawyer like me, and what to talk about seniors.
Madan sir, you're not junior lawyer. Okay.
So from fee point of view, I'm saying okay.
Anybody is coming to corporate professional forum, he's not junior lawyer, so ध्यान रखना, ठीक है? Okay. Now, friends, it's a time.
Other issue which Rishabh talked about is PUF applications. The clarity should be provided in every resolution plan itself. That number one, after approval of the plan, who is going to pursue these PUF applications? Some call it PUF, some call it PUFE, or let's call it avoidance applications. Who is going to pursue these applications? Who is going to fund the litigation cost? And who is actually going to be the beneficiary of these applications? Because nowadays the trend is that before approval of the plan, the adjudicating authority is not considering these applications. Because in these applications, there are multiple respondents, multiple litigation. It's not easy for the adjudicating authority to dispose of these applications. And my humble request to RPs also, before filing these applications, whenever you have your own determination, your determination should be very clear. Simply because IBBI is asking you to file this application, do not file the applications. I tell you, in 90% of the cases, these applications are being filed on the basis of forensic audit report or transaction audit report, which in itself is not exclusive. The words like probable, possible, likelihood, and these words are used in this FAR and TAR. And once you file an application on the basis of this report, which is not the conclusive or comprehensive, these applications are liable to be dismissed or rejected after a longer period of time of the entire delay and the litigation cost. So even that care should also be taken by the RPs as well as by the successful resolution applicant.
Okay, now this is a time for some questions. So you have given answer of various questions. So my first question, which I am asking, Madan sir, what is the title of the case pending in bench 2? You have given.
I've already given the reply.
No, but that is okay. That is 1-to-1, but it should be for public also. So I'm just taking this.
GGPL.
Okay. Pawanji, please ask Shivam to share presentation. We'll give it to you. Actually, it is approved by RP but not released. Okay.
Hey, that's not the question. There's a prior question to that also, that the council fees has not been paid. Council fees has not been paid.
Okay. Now, a listed company is under corporate insolvency resolution process and under moratorium as per section 14 of IBC. Can stock exchange levy penalty, fine or the listed entity for not complying with the SEBI LODR? Manoj or Amit? Quick answer, because now it's a rapid round. So notice.
No. If it is during CIRP process, the responsibility is of insolvency professional, and the IBBI circular says the penalty has to be borne by the insolvency professional who is in charge running the CIRP process.
But my take is on that an insolvency professional can endeavor to comply with this. He cannot ensure complete compliance. So in case of, despite all his endeavors, is not able to comply with that, no penalty should be levied on the insolvency.
Yeah, of course, it is adjudicatable offense. So adjudication will happen. He will defend himself.
Okay, Manoj, whether stamp duty chargeable on immovable properties took over by SRA or NCLT may give waiver of stamp duty and other charges?
There is no waiver. There is no waiver. Obviously, if the plan says that certain assets would be disposed of or acquired by the SRA, then certainly duty need to be paid on that.
No, but Manoj, the question is, if the SR is acquired the company as a whole.
Like if the company is being acquired, obviously there is no question of a stamp duty payment.
If there is a transfer of asset, then duty is payable. Otherwise,
yes, that's what I'm saying. If there is a specific provision that
there is only change in shareholding pattern, no stamp duty.
But
Yeah.
when should I pay?
Sorry?
When should I pay? Because
Sir,
I didn't have
no,
money.
no.
Again, whenever transfer will take place, whenever the vesting document will be executed at the same time.
Can I ask NCLT that I will pay,
No.
but I don't have money, so please give me time for 2 years or 1 year?
No, there is no such provision.
Okay.
If you are a resolution applicant, you have to factor in all the costs involved for the resolution plan.
Madan sir has a different view.
No, my question was different, that in case of liquidation. In liquidation, when the sale letter is issued to the successful acquirer, is any stamp duty required to be paid at that point of time?
As there are specific provisions in some of the state legislation where they give exemption to
Sale certificate.
the decrees and liquidation notes. But for IBC, there is no specific change in the law. I don't think there will be any exemption. If you
No, but
want to go for
I have certain judicial pronouncement where this sale is different than the sale letter issued under Section 17 of the Transfer of Property Act. So therefore, in this case, no transfer duty is, no stamp duty is leviable.
Okay.
Yeah, so that will be based on the case, yes.
Okay. Whether OC can file an application under Section 9 where there is already a pending complaint under MSME Act filed by some OC against same CD.
Yes, yes.
Yes.
If the threshold is breached, yes, you can.
How do the rights and priorities of financial creditor differ from operational creditor in the resolution process under the IBC?
He gets a seat in the COC.
Okay. What are the major compliance challenges for companies undergoing resolution under the IBC, particularly in relation to SEBI and tax laws?
This is what we have been discussing for the last couple of hours.
Yeah.
Okay. What are the conflicts between IBC provision and other regulatory frameworks and how these conflicts are resolved?
Section 238.
So
Clearly says that is overriding.
one conflict which I particularly understand, whereas insolvency law says the suspension of the powers of the board. According to that, many of the companies are not holding any board of directors meeting, whereas under the Companies Act, there is no exemption for holding of a board meeting, and even the MGT 7 returns which are filed does not provide any exemption from filling the date of board meeting for the particular year. So there needs to be, again, I'm saying the same thing, that same ministry should come out with a clarification whether it is required to be held or not. Although every professional is doing his own interpretation, and few are holding, few are filling the dates of COC meeting in their MGT 7, few are not filling, few are attaching clarification.
Okay.
To put to
No,
rest.
Amit, मेरा इसमें ये कहना है, Companies Act is under MCA, IBC is under MCA.
Yes.
RP is facing this problem for last 7 years. Why MCA does not come forward and provide clarity on this? This is not ease of doing business.
In fact, sir, IBPI circular that IP need to comply with all the laws is also very vague kind of notification. They should clarify whatever can be done by the RP individual capacity he can do, but the board meeting, the shareholders meetings are cannot be an obligation of the RP.
Absolutely.
Okay, how have recent amendment to IBC affected the resolution process and the interaction with the other laws? Is improved
Which recent amendment? After 2021, I don't think there has been any amendment.
There is any amendment, yes.
The last law, recent means the last that has changed, that has improved something.
IBC has actually changed the entire ecosystem.
Okay, what are the key responsibility of an insolvency professional ensuring?
Pawan ji, इसको ऊपर मैं एक सिर्फ figure देना चाहूँगा. That till date, out of the resolution plans, approximately 3.5 lakh crores has been recovered by the lenders. But if you see the number of applications which were filed and withdrawn, and a settlement has taken place post admission of the application and post the filing of the application before admission of the application. During that period, approximately 29,000 cases have been resolved, and more than 10 lakh crores underlying debt was part of these applications.
So
that is a real
victory. So obviously, that statement was given by FM Madam also on the parliament.
Madam has also taken this figure from IBPI newsletter.
No, you remember Sahu sir's statement? Then he has given this in our book also.
Best use of this law is that this law is not used.
The law should not be used. Okay.
Yes.
The best use of this law is this should not be used. Okay.
Yes.
What are the how can stakeholders prepare for anticipated change in regulatory landscape affecting resolution plans? I think this is some question which is vague. What strategy can be employed to balance the interests of different stakeholders in resolution plan? Last question.
Can you repeat the question, please?
What strategy can be employed to balance the interests of the different stakeholders in resolution plan?
So I think balancing is not a problem. This law is providing sufficient checks and balances all across, right from the very beginning. When you take the committee of creditor, which is chaired by a insolvency professional who is independent body, independent professional, but he does not have any voting right. Whereas the financial creditor who have a voting right, but none of the person from COC is made a chairman. So the controlling body is independent professional, whereas committee of creditor is the decision-making body. Right. Likewise, there are many places where insolvency professional has to act subject to the approval of committee of creditor. So insolvency professional is also not made a supreme authority in many of the situations. So it's a question of checks and balances. And both of these bodies are again subjected to the adjudicating authority. That is again the principle of checks and balances. So I don't think there is any conflict or any gap with regard to the checks and balances. It is very well balanced all across.
Okay. Okay.
Pawan ji, mera isme maana the balancing the interest of all the stakeholders on papers only. The COC comprises of financial creditors, and they simply take care of their own interests. They don't take care of any other stakeholders.
Absolutely right. Absolutely.
Let's be practical on this.
Yes. And obviously, RA also wants to satisfy them so that the scheme is approved. So that is the priority, other than those which are mandatorily provided for, like employee or workman dues, for which you have to make specific provision. Nobody cares about anyone else, because in most of the cases, the amount is very small, which
Okay,
is
friends.
getting distributed.
Friends, it said only 3 minutes left. We have to close this. So now, as a ritual, we are taking closing remarks from everybody. So Rishabh, I will start that what is your feel about it? 30 seconds only. Everybody should keep ready that overall view they want to give. Okay, Manoj, you start.
I think, sir, the law is very important and very capable law, and it is changing the landscape. Only thing is the ecosystem is still evolving. So it will take some time, but it has to be there. Like we said, if it is creating the discipline in the financial discipline in the corporate world, that is more than important. So I think that's good.
Okay, Amit.
Sir, I keep on saying that as long as business is there, risk is there, and risk is there, so there will be always a stress. So de-stressing will always be required in the ecosystem, and insolvency law is one of the best evolution that country has seen over a period of time. I think this law is going to remain there. We are all very positive about this law. And I'm sure maybe small tweaking may be required over a period of time, but this law and the insolvency professional and insolvency profession is going to remain there for de-stressing the stress in the business world.
But Amit, political parties are saying you have exempted loan of these people. They involve and include.
People will have their own wisdoms and their own statements. Now they will choose their words and they will keep on saying. But ultimately, we have realized what the figure Madan sir was giving, 3.5 lakh crore plus the figure which has settled outside court is not a small figure. So ultimately, result speaks a lot.
Rishabh.
Yes, sir. So in my opinion, I guess this Insolvency Bankruptcy Code, it's a very specified law in terms of timelines. Like we have timelines for each and every process. If we compare it, the liquidation process in Companies Act, it takes the official liquidator is appointed, and generally the process takes 5 years or maybe up to 10 years. But in IBC, the process is very specified, and the timeline for such process is limited to a period of 1 year. So I can say that the key attractive feature of this IBC law is the timelines, which we have not seen in any other law prevailing in India till date.
Madan sir, last comments.
It's a wonderful legislation with a very well articulated preamble which talks about rehabilitation and restructuring without even referring to liquidation, which is the ultimate resort. This legislation has created fear amongst the willful defaulters, and very rightly so. That was the need of the hour. The only thing which needs to be done is now we need to have a robust adjudicating authority. And looking at the need of the hour, our central government through the Ministry of Corporate Affairs should come out with the amendments which are required, looking at the various judicial pronouncement to restore the confidence of the stakeholders in this legislation and to have a wonderful ecosystem with an objective of ease of doing business.
Thank you, Madan. Thank you. So, thank you very much, all my panelists, Amit, Rishabh, Manoj, Madan sir. Madan sir, thank you very much. You are not in town, but despite of hurdles, you have participated. So, thank you very much.
With no
Friends-
hurdle, I'm here in Goa.
Okay. So, I don't want to say in Goa, but you have told.
So somebody can say if I'm not in formal dress.
Okay.
I
So
just want to
friends,
clarify that.
so thank you very much. We enjoy, and when we get queries from your side that enhance our knowledge, our speakers' knowledge, our learned panelist knowledge, that is a feedback which we are getting. And then whatever we are getting, feedback, whatever questions and the issues, we compile it, give it to the regulator. So regulator is always in the process of changing. So this is the advantage of these webinars. It is a good give and take. So friends, our journey of this sharing knowledge will continue. And next Friday, that is 5th September, Teachers' Day, Dr. Radhakrishnan Pillai's birthday. Okay, so that is we celebrate on Teachers' Day. So we are having our 188 webinars. Section 188 is very complicated in Companies Act. So we have 188 webinar on the Teachers' Day, and we want to give knowledge. And this topic we have selected: inorganic acquisition, navigating the emerging landscape. So whenever you are doing business, it is not always that you build and do this, because Chanakya has said, one life is not sufficient to do something, do mistakes and do something. It is you learn from the others' mistakes. Same thing applies here, that you just do try to acquire something, try to do inorganic acquisition so you can become big, giant. And this is the need of the hours. This is the need of the India, that we should not be do business, we should become big. 1947 is a year we have to achieve something great, but our journey should start now. So we will do this program. And interestingly, I just want to announce one more announcement. On the day of this 5th September, we are launching our new business model, our new website, and that is Deal for Business on the particular day. So it will be useful for the industry, that they can come, they can see, because we are doing various transactions, sending various deals. But here you can 24/7, you can see, you can put your deals and you can do. So see you till then. 5th September, Teachers' Day, we'll meet again. Till then, thank you very much.
Thank you.
Pavanji,
Yeah.
my salute to you for your passion, your zeal. That it you suggest one life. In one life, last 4.5 years. This is 187th program today. It's not a joke. I think with the professionals owe something to you, and professionals certainly salute for your passion.
Thank you very much. Thank you. Thank you. Thank you.